Welcome, everyone. I'm David Abel, outside counsel for Battea Class Action Services and managing attorney of U.S. Market Advisors Law Group. And today we are discussing shareholder litigation in Ireland, specifically the state of securities fraud litigation and related claims available to investors. Joining our call today is Kyle Nolan from the group. Maples is an international law firm that for decades has served clients in the financial services industry. Kyle is an attorney on the dispute resolution and insolvency team in Maples office, and he has extensive experience in advising domestic and multinational clients across a broad range of complex commercial disputes, particularly in the areas of banking, financial services, professional negligence, and public procurement. Kyle is also highly experienced in dealing with regulators and in advising clients on regulatory investigations and related litigation. Kyle, it's great to have you here. Thanks for taking the time.
Likewise, David, thank you.
All right, so before we get started, like any good attorney would do, we want to provide a quick disclaimer. And that is that the views expressed today, of course, are not necessarily representative of our law firms or our clients or employers. And also, this discussion is not intended as providing legal advice. You should, of course, consult with an attorney about your specific situation before making any decisions related to topics covered in today's discussion. So with that, let's jump in. If I could, Kyle, I'm going to set the stage a little bit on Ireland, and you tell me if I have anything wrong. Ireland, my understanding, is a key financial hub and for many banking institutions and a gateway to Europe and the EU, particularly for investors and companies that primarily speak English. And I've seen for years that Ireland has been very advantageous for corporate entities in regard to tax and the ease of corporate formation, and just the country generally just having a pro-business atmosphere. And also I should mention the Euronext, or the exchanges there, and I know there are several hundreds, if not thousands, of issuers that you can buy and trade there. So with that kind of thought, an intersecting one is shareholder litigation, and particularly litigation structured as class action or collective actions, which we want to speak about today. It's occurring with increased frequency in Europe, as you know, and the Netherlands and UK are arguably two of the most active jurisdictions. But for better or for worse, at least from my perspective, this side of the pond, the United States, Ireland seems to have strayed away from that, or is not as active a contributor as some of the other countries. So can you just go over briefly why is that not happening, or what's different about Ireland where we don't see it as active, at least from the outside perspective?
That's all correct, David. Ireland has and remains a very attractive destination for financial services as well as foreign direct investment. It's home to many of the top companies in tech, financial services, funds, pharma, and life sciences, all industries which would often give rise to class actions, at least in other jurisdictions. From a litigation perspective, it is also an attractive venue for disputes for a number of reasons, including the fact that it is now the only English-speaking common law jurisdiction in the European Union, and it has a highly specialised judiciary and legal profession. And in fact, it's government policy to promote Ireland as a forum for determining international commercial disputes. So from the perspective of a shareholder, there are a number of reasons why they might think that Ireland ought to be fertile ground for such collective actions. However, as you correctly noted, has not proven to be the case, at least not yet. Two reasons are as follows. Firstly, unlike many other jurisdictions, including the US, the UK, and a number of EU member states, including the Netherlands, currently at least, there is no formal class action procedure for the existing mechanisms for such disputes, such as representative actions and test cases, are not efficient or appealing, particularly from the perspective of shareholder action. Reform, however, is due very soon, particularly through the transposition of the EU directive on representative actions for protection of collector interests of consumers, which is coming into effect later in 2023. As you're well aware, that will provide for an EU-wide consumer class action framework and the taking of actions by designated qualified entities. In the case of Ireland, at least, that will represent a fundamental change to the law concerning consumers and class actions. Separate to that, we will also be legislating in the next 2 to 3 years for a comprehensive multi-party action procedure, similar to the group litigation order procedure in the UK, which I believe you're familiar with. The second key reason is that there remains a general prohibition on professional third-party litigation funding in Ireland. So you can only fund a case unless you have a legitimate interest in the litigation. So an example of that would be a shareholder or a creditor. But reform is also expected in that area in the near future, and indeed the Irish government very recently published draft legislation permitting litigation funding of international commercial arbitration proceedings.
Okay, so understood. Ireland's essentially taken a different path, but something could be happening in 2023 or soon enough. But if we could, let's dig in a little bit on what we can do or what is available at the moment on shareholder rights. I mean, essentially, if you think of like a U.S. style class action or securities fraud class action, is that type of claim available in Ireland? Is that what I'm hearing you saying, or is there arbitration or mediation, or is there some other way that shareholders can file a claim, but it may not be called that, or really that kind of process of litigation?
Yeah, so we don't have an equivalent system to the US, or probably not any near equivalent system to the US. So if you were taking a kind of classical securities action, it would be by way of plenary proceedings, and you would take those claims usually on the basis of claims in contract and tort. So claims for breach of contract, misrepresentation, negligent misstatement, and as the case may be, fraud. There are also a number of statutory causes of action under Irish companies legislation, which, for example, provide for a civil liability for loss arising from statements or the omission of information which is required under EU law in prospectuses, as well as breach of market abuse regulations. There's also a very broad cause of action under central bank legislation for damages suffered by customer of a regulated financial service provider as a result of any failure to comply with financial services legislation. And that is a very broad list of legislation. As regards arbitration, Ireland adopted the trial model law, and Irish courts are strongly supportive of arbitration. So where you have a claim which is the subject of an enforceable arbitration agreement, the Irish courts will stay that claim, stay any court proceedings in favour of arbitration. As regards mediation, in Ireland at least, it's an entirely voluntary process, so that wouldn't preclude you from pursuing such claims.
Okay. Okay, so I think I'm hearing what you're saying on that. But if we could, let's go through a little bit of a hypothetical, just to be clear on the type of claim that a shareholder investor is watching this might have. So let's assume that we have an investor. They lost 10 million euro. They think it's because of a fraud that the company has essentially defrauded them or said false statements that turned out that later they learned about and caused a price decline, and they want to file a collective action or class action. And I'm hearing what you're saying, that there's no mechanism for that. But is it possible for them to be successful if they pursue it alone, or is it possible for maybe the same law firm to have a group of clients file individual actions together, so not necessarily a class, but at least kind of build off of that kind of collective filing or filings?
So yeah, as you noted, we don't have a formal class action procedure, so unfortunately, the investor would have to pursue its claim alone, at least initially. However, if there were multiple investors, as you know, who have cause of action which arise from the same circumstances, then it could be possible to determine that action by way of a test case. So in that scenario, the Irish courts will seek to establish a precedent for all of those claims by hearing one or a number of those cases, which replicate the circumstances of all the claims, of the wider claims, and then stay the remaining pending resolution of those test cases. It's not the most efficient system, at least compared to other procedures in other jurisdictions, but it's how the Irish courts would have typically dealt with many of the mis-selling claims which arose from the global financial crisis. It's also potentially open to a shareholder to proceed by way of a representative action. So a shareholder can bring a case on behalf of a group. However, there are limitations with that procedure. For example, the shareholder must share the same interest in one cause of action. There's also no clear precedent for the granting of damages in such cases in Ireland. Consequently, it's not often utilised, at least not in our experience. It might also be open to a shareholder requesting the court to consolidate all the claims or to proceed by way of a coordinated hearings. So basic case management on the part of the courts, and they're quite amenable to those types of applications, at least. However, in any event, regardless of what way they pursue it, there is little or no scope for that investor to remain entirely passive if it wants to seek redress, which is unlike the US, at least.
Okay. So it's certainly a different system than what I do. And one of the big distinctions, at least we have in the US, is often if there's an IPO, there can be a action against that if perhaps the prospectus or the offering documents had false statements in it, and it's generally pursued, at least the elements that need to be proven is pursued differently than a securities fraud case where you purchase shares on an exchange in a secondary market, and it's a little bit higher standard of pleading, and frankly a little bit more difficult case to litigate. And I believe in the UK, at least, there's a difference between an issuer claim and a secondary market or secondary exchange claim. It is perhaps if you have those separate claims in Ireland, can those be pursued differently, or if what I'm hearing you saying earlier, it's essentially it might be based on contract claim, and so it's might both follow the same path, either whether or not it's an issuer claim or a secondary market claim.
Sort of sorry to have to say this, but it would depend on the specific facts of the investments. But given that there were separate purchases from separate exchanges or offers, you could be looking at two different claims. With regard to the IPO, that investor could pursue the common law claims that I mentioned in contract and tort, sort of similar to the type of claims that will be available in the UK. However, the purchase on a secondary exchange faces greater hurdles if relying on those causes of action for certain obvious reasons, including the lack of any direct contract and the requirement to prove any duty of care on the part of the initial offeror to that purchaser. As I mentioned, there is a provision under Irish Companies Act which provides for civil liability for loss arising from misstatements or omissions in a prospectus. That provision, however, extends liability to quite a number of persons, including the issuer of the prospectus, the offerer of securities to which the prospectus relates, as well as any person who is sought to have securities admitted to trading. So you might argue that certainly captures the secondary purchase.
Okay. And so that goes right into my next question. Under that law, can you perhaps bring in an auditor or some other party that might be associated? Would they have liability under that law, or is there any way that they might have exposure? And for example, if an issuer may be defunct or have no money, where there may be someone else out there who can help compensate investors.
Mm. So yeah, such parties can and indeed have been joined as parties historically, certainly to some actions, particularly directors and promoters who have been involved in mis-selling claims. However, whether or not such claims are plausible will turn on the facts of the particular case, especially if there's typically no direct contract or contractual relationship between the investor and those parties. So in order to establish a claim in tort, which is what you'd be left with from a common law perspective, an investor would have to establish on the particular facts that a duty of care was owed to that investor as opposed to the company. As I already mentioned, there is a provision under the Companies Act, which I know I keep harking back to, but that imposes civil liability for misstatements and omissions, as I said, to quite a number of persons, but that also includes directors, promoters, as well as there's almost like a catch-all, as well as all persons who have authorized the issue of the prospectus. As regards to directors, well, the general rule is that a director owes his or her duties to the company and not to its shareholders. In certain circumstances, it may be possible to fix those directors with liability. So, for example, where a company is being wound up or is in an examinership, insolvency process, it may be possible under the Companies Act to impose civil liability on those directors or auditors, as the case may be, for fraudulent or reckless trading. Interestingly, in a separate context, in a decision called Powers and Grain Mountain Management Limited, the Irish court very recently, in fact, in the last 2 to 3 months, held directors and shadow directors personally liable for funds which were misappropriated by a company as part of a fraudulent investment scheme worth in excess of 180 million euros. The reason why it's important is because this represents the very first time that an Irish court has ever pierced the corporate veil and held directors personally liable. Well, you might say investors might be buoyed or encouraged by that case from the perspective of pursuing directors. It's still a high bar, and it would likely require some element of fraud on the part of those persons. One, I suppose, asterisk to add towards the end of that is that investors should bear in mind the rule against reflective loss, which still exists in Ireland, and that's to the effect that where loss is suffered to the value of the company, and by extension the shareholders' interest, as a consequence of wrong committed against the company, then it is for the company to pursue that loss. Well, questions have been raised about the scope and application of that rule, especially in the present day. It should still be kept in mind.
Sure. Okay. So kind of back to the earlier hypothetical, a final question on that is, let's say an investor has, talked with their attorney and they believe that their damages are enough, or the harm is, aggravating enough where they do want to pursue a claim. And let's say this entity is domiciled outside of Ireland. In other countries, we went through this in the U.S. several years ago. There was this question of whether foreign investors can file claims. Is there any preclusion in Ireland on outside investors litigating there?
No, and I know that you guys were looking also in the context of Australia, that I think is the Morrison case. That there are no general preclusions against foreign entities from the US or the likes from pursuing securities claims in Ireland. In the case of a US entity, it would still be subject to the common law rules of jurisdiction as regards demonstrating that Ireland is the appropriate forum for any dispute. So provided they can satisfy those rules, it should be able to pursue a claim here.
From what I'm hearing, I think I know the answer, but if an investor wants to file a claim, essentially they're going to be known to the defendant, right? There's no way to hide behind a class.
Yes, yeah. You practically answer the question for me. Given that we've no formal class action procedure, and certainly no procedure which affords anonymity to a claimant. So all of those hurdles will remain if pursuing a claim in Ireland. That person will have to, or entity as the case may be, will have to issue its own set of proceedings in its name, so that will be publicly available information. While it may be possible to have a group of claims determined by a test case, and the Irish courts are very much keen on efficient case management of such claims. As I said, they'll still have to issue its own claim, meaning that it cannot remain anonymous or avoid active participation or indeed legal fees, at least not initially. Now, if you got to the point where there were, hundreds or thousands of the case would be of similar cases issued in the High Court in Ireland, well, then the courts will grab the reins and try and, insofar as possible, proceed by way of test case and stay as many of those proceedings as possible. In which case, depending on the investor's preference, maybe an option at that point for the investor to basically take a passive role. But that's really the only extent to which you can do that. As regards other hurdles, Ireland has a relatively onerous discovery regime, at least relative to the other jurisdictions in the European Union. But reform is planned within the next 2 years, thankfully. Well, that can offer a strategic advantage, especially for claimants in class actions. The discovery obligations are still the same for all parties. As regards testimony and whether or not an investor will be required to testify, it'll depend on each case. As I said, it may not be required where another case is chosen as a test case for the broader claims. However, any claimant should operate on the assumption that it will be required to give oral evidence at trial. So certainly when they're issuing proceedings, that should be kept in mind.
So Kyle, thanks for that. Let's turn quickly to third-party funding of litigation. I think you mentioned earlier that it's currently prohibited in Ireland, but I also understand there may be a change. Can you briefly touch on what we should be watching for?
Yeah, of course. The prohibition has been in place for quite some time, and it was recently reinforced by quite a number of Irish decisions, most notably a Supreme Court decision in 2017. And because of the significance and complexity of the issue, it effectively kicked the matter to the legislator because it's basically a matter of policy. However, the Irish government has been relatively proactive on this particular issue. So it recently published draft legislation permitting litigation funding of international commercial arbitrations. So that legislation is expected to be enacted in 2023 and could assist certain types of shareholder litigation. As you're probably aware, the EU-wide regulation is likely coming down the tracks following the publication of the European Parliament's report in September 22 on responsible third-party litigation funding. So there may well be movement on the broader prohibition of litigation funding in the near future. In terms of key legislation or developments to watch out for, the two key pieces of legislation to watch out for in 2023 at least are the legislation which is due to enact the provisions of the directive on consumer representative actions, and separately the legislation which is expected to provide for third-party funding of international commercial arbitrations. Separate to that, Ireland has also conducted a root and branch review of its civil procedural system, and the Irish government published its implementation plan very recently. So that will involve the implementation of fairly significant reforms across the entire civil justice system over the next 2 to 3 years, which are basically intended to make litigation more efficient and cost effective. And that will include legislation for a comprehensive multi-party action procedure along the lines of the UK's group litigation order that I mentioned.
Okay. Well, great. So this has been wonderful information. I'm sure investors appreciate it, and always know kind of what the risk and what the experience would be like if they do need to file a claim. And we see that Ireland does have a little bit of a different path than other countries in Europe, but I'm sure that there's advantages to it. I'm sure corporations kind of like some of that security and some of the pro-business environment there that makes it a little bit more difficult, frankly, to file a claim. So Kyle, this has been a great conversation. Really appreciate your insight on these shareholder matters. And investors like certainty, and so it's like I said, it's good to know what they can expect, and perhaps next year, as laws change and are implemented, we may have even more certainty around some things like third-party litigation funding, and whether or not there will be more litigation because of it. So until then, I really appreciate your time. Thanks again, and I hope everyone has a great day.